of Salmon for opening remarks on Amendment H 8276.
Thank you, Mr. Speaker. What this amendment does is makes it a criminal action to allow a minor to access pornography in a K-12 school as it would outside the school, which is a serious misdemeanor for obscene material and an aggravated misdemeanor for hardcore pornography. It also allows a parent to bring a lawsuit against a school that knowingly allows a minor to access pornography, both for injunctive relief and damages. If county attorneys don't prosecute, parents have this option. This puts parents in the driver's seat. This does not change the definition of obscene material, which applies to what is not appropriate for minors and has been on the Iowa books for decades. It is derived from a Supreme Court ruling decades ago and is found in Iowa Code Section 728.1, Paragraph 5. It also does not change the definition of hardcore pornography, which is a lower level of depravity and is not even appropriate for adults. It is found in Iowa Code Section 728.4 and uses the same Supreme Court-derived definition. An administrator or teacher found in criminal violation would lose their license and the school would have a civil penalty assessed against it. The penalty would be dropped as soon as the pornographic material is removed from the school. An administrator or teacher found guilty of a court injunction would have their license suspended. There are 2 county attorneys that have already been approached about bringing a lawsuit regarding pornographic materials in school. They have said that they cannot bring a suit because Iowa Code 728 is too vague and needs to be clarified regarding schools because schools have special protections in this section of the code. This amendment makes those clarifications and removes those special protections. The vast majority of our teachers do a great job. This amendment targets the few bad actors we have in our schools and places no further burden on the rest of our teachers. Just a few years ago, we made it a crime for parents to give their children pornographic material. So right now, our law says no one can give minors pornographic material unless they are in a school. And if they are in a school, they can get all the pornography there is. The law is so vague that there is, for all practical purposes, no law against it. Just let that sink in. This is appalling and unconscionable. We are the government. We must protect our kids. Our job is to put laws in place to do that. It should not matter your occupation. Everyone should be required to protect children against pornography. Our children should be able to enjoy the equal protection of the law from everyone. I've also heard it said that it's the parents' job to protect their kids as a reason for not putting criminal penalties or a pathway for a lawsuit in place. So why do we bother with laws prohibiting minors from getting tobacco, alcohol, or drugs? Why don't we just leave it up to the parents? And that's because parents need government to do its job to put effective and sufficient laws in place to protect kids. That's its job. It's a partnership between parents and government. Pornography is every bit as dangerous and lethal as tobacco, alcohol, and drugs, yet we are going to allow it at the very place kids spend most of their day. Taxpayers don't provide tobacco, alcohol, and drugs to kids. So why should the taxpayer be providing pornographic materials to them in their schools? I've also heard it said that only a very small percentage of school personnel are involved in giving kids pornographic material as a reason not to criminalize it. Well, only a very small percentage of citizens commit murder or burglary, yet those activities are criminalized. We are at a watershed moment. We are deciding how much protection to give our kids for pornography in the place where they should never get it, but are getting it. We have to stand up for our kids first and foremost, and if we don't, we are failing our kids. If we don't take more action, here is what we will be allowing to stay in our schools, realistically speaking. Sexually explicit and graphic detail of heterosexual and homosexual sex acts, incest, pedophilia, bestiality, rape, masturbation, obscene language, and more. Google flagged images from one book as adult sexual content, and Facebook said the images violate community standards on sexual activity. We need effective and sufficient laws with teeth to provide the tools needed to make a difference. Leaving decisions in the hands of bureaucrats will not be sufficient or effective enough in helping parents to fully protect their kids. Bureaucrats make decisions behind closed doors and are unaccountable to the people. We need parents to be able to take action, to file a complaint on criminal charges. We need them to be able to file lawsuits that actually stand a chance of winning in order to protect their kids and all the other kids in their school. Criminal and civil actions are very public and shine the light on everything, making it easier to hold those involved to account. Pornography is an equal opportunity destroyer, and it calls for an equally strong response from government. Those are my opening comments.
Chair recognizes the gentleman from the Wise, Representative Kerr.
I believe this is already covered under Chapter 782, and I question if his amendment is germane.
Will the lady from Blackhawk and the gentleman from the Weiser approach well? Point is well taken. Chair recognizes Representative Salmon for a motion.
I move to suspend the rules to consider Amendment H8276 and ask for a division in a record.
The lady from Blackhawk moves to suspend the rules to immediately consider Amendment H8276. Request division in record. Seconded by the gentleman from Muscatine, Representative Cisneros. This is now a record roll call vote. Clerk will machine receive your vote. Kaufman votes no. Buslow votes no. Mitchell votes no. Bennett votes no. McClintock votes no. Donahue votes no. Wolf votes no. Losey votes no. Jones votes no. Richard votes no.